you mentioning item number 1, payment is 16 of 123.
Already in this matter, service has not yet been effected.
You are for the appellant. Reporting. Record an order. Land advocate representing the appellant has prayed for accommodation to effect service of notice upon the respondents. Stop. List the matter before the next circuit in order to enable the land advocate for the appellant to complete service and file affidavit of service.
Same order. 17 of 125.
Service is not complete. Same order.
Number 3, come to PFP 7 of 124. So very good petition.
Service is complete so far application is concerned. Who is appearing for the respondent?
But compared with third of that, though there is not say that I have come to the application here now. So there are some cases.
Go. And Miss Nag is appearing for whom? So where is she? What possible?
May I submit just one thing? This is just an extension. The matter is also.
That I know, but application has to be disposed of in presence of the learned advocate representing the respondent.
Lord, we have served. I have an endorsement in this, my lord, because I have been
Yes, where is the order? You don't have copy, no service has been effected. Let us see.
my lord, the order is at page number 12, my lord.
Cooperative bank, no service.
My lord, they don't have any issues.
No, you have to serve.
Not served, my lord. I served. The authorities are also here. They say they have served. Not promise I can file affidavit service during the course of the day.
Show me that you have served upon the bank. At the time matter is taken up for consideration when learned advocate representing pro forma respondent number 3 Andaman and Nicobar State Cooperative Bank representing pro forma respondent number 3 has prayed for accommodation. Stop. Service in respect of respondent number 3 is not complete. Stop. Learned advocate representing the respondent petitioner has prayed respondent writ petitioner has prayed for accommodation. Stop. Learned advocate representing the applicant/respondent is directed to complete service by 7 days from date and file affidavit of service on the next date. List the matter under the same heading before the next circuit.
Blair.
Item number 4, FMAT WC on of 924 with item number 5 and 6.
Lord, it is that matter, my lord, wherein I have been appointed to be as a counsel for the Labour Commissioner. And the notices have been issued to the Labour Commission also for engaging a new lawyer because I have been engaged as a junior counsel to the senior counsel Satar Chakravarti. The Lord has already passed an order.
For making an alternative
Arrangement. But
So who is appearing for Labour Commission?
Lord, they have processed the file, it seems. Let it be. They have processed the file. And it will during the week, the new counsel will be appointed. So let it be not today, not all next circuit, so that in the meantime they can make a.
Now you are representing appellant.
Yes.
How this is possible in the same matter? You appeared for the Labour Commissioner and subsequently you are appearing for the appellant?
No, because earlier what has happened, Mr. Chakraborty was on panel. Now he is being designated as senior counsel. There is a notification that.
But same of the advocate cannot participate in the proceedings where there is a conflict of interest. That is not permissible.
And that's
Yes,
We will
since he appeared on behalf of Labour Commissioner being one of the respondents before the trial court as one of the respondents. He cannot appear on behalf of the appellant, at least in this other matter he can. But in this matter he cannot.
Yes, yes.
We shall request them to make.
No. Yes, my lord.
You cannot.
Yes,
Mr. Divedi.
No, my lord. I am Rakesh Kumar, my lord.
You should not appear in this matter. This is a conflict of interest. Once you
Absolutely.
appear on behalf of the Labour Commissioner, now on behalf of the appellant, in an adversarial litigation, you cannot. Have you served notice upon respondent number 2?
Has been served, and they said that they have made a process the file for engagement of counsel.
Accommodation has been prayed for on behalf of the parties to make alternative arrangement as directed by this court in the order dated 28 January 2025. Stop. List the matter before the next circuit.
Obey.
Item number 7. WBC 10 of 2024.
But I am for the respondent. Mr. Nag is for the appellant and Mr. Tabriz is for private respondent in this matter, my lord.
Item number 7.
Item number 7, my lord.
The So, at the time of call, no one appears for the petitioners and private respondents. Stop. However, administration is represented by learned advocate who has prayed for accommodation. Stop. List the matter on the first date before the next circuit, subject to convenience of the bench.
Item number 8. WBC 19 of 2024.
We are appealing for the respondent.
My lord, here, my lord, we have informed, but I just. But here there is a statutory appeal before the President of India. So
So that is pending.
that is pending. We have, my lord.
Just a minute, let us go through our meeting. matter is taken up for consideration when no one appears for the petitioner and no accommodation is prayed for. However, on behalf of the respondents, a communication dated 6th February 2025 issued by the Assistant Secretary within bracket Vigilance, VIG close bracket, addressed to EO to Chief Engineer, Nirman Bhavan, APWD, Port Blair is placed before this court and same is taken on record. On next paragraph, on perusal of the said communication dated 6th February 2025, it appears that appeal is to be processed for consideration within 2 or 3 within 3 weeks. Within 3 weeks. Stop. Next paragraph. In view of aforesaid position relating to the appeal preferred by the writ petitioner, hearing of this matter stands adjourned. Stop. List the matter in the second week of next available circuit when the learned advocate representing the respondents would submit a report relating to the present status of the appeal. Where is Mr. Chakraborty? Yes. Why to be mentioned? There was a direction. There was a direction for filing paperwork.
Challenged by the insurance company, whom I represent. That matter not before the other court, and this matter is stayed with that matter.
বসো বসো let both the matter, already there is an order by the coordinate bench that the both the appeals should be heard analogously. Who has mentioned this matter for matter has come up in the list under the heading to be mentioned, quote unquote to be mentioned, at the instance of the learned advocate representing the appellant. Stop. Next paragraph, today learned advocates representing the respondent insurance company, respondent insurance company has placed before this court an order dated 5th February 2025, passed by a coordinate bench, wherein the court directed present appeal to be heard along with FMAT, along with FMAT within bracket MV close bracket /1 of 2025. Stop. Let both the appeals be heard together. Stop. List the appeals. In this matter, MV1 of 2025, a paper book has been filed.
Same documents are there, I think for exemption also.
You are appealing for the claimant. Very well. Let both the appeals be so that delay has not been condoned. Let both the appeals be let both the appeals appear when leave is granted to the learned advocate representing insurance company, being the respondent, no, being the appellant. Against the same order, insurance company has preferred an appeal and the claimant has preferred. So, where is the delay in which matter? No, MV1 of 2025. What is? What I was
So
talking.
the things, then we use that. So, 20% of the functions are going to be applied.
To move. First, your appeal should be registered. Today, this matter cannot be directed to be heard as treating it as appeal. First, where is your application? Then today I cannot direct. First, this section 5 application has to be allowed. Then it is to be registered. If otherwise the appeal is informed, then question would arise that your appeal, insurance company's appeal, to be heard along with claimant's appeal. Strike of entire order. Matter has come up. The appeal has come up under the heading to be mentioned by the learned advocate representing appellant/claimant. Stop. Next paragraph. Learned advocate representing insurance company, being respondent number 2, has submitted that against same order, September 2024. Against same order or against same judgment dated 13th September 2024, insurance company has preferred an appeal, being FMAT MV1 of 2025. However, it is further submitted that an application under section 5 of Limitation Act has been preferred in connection with the said appeal, since there was delay in presenting the appeal. Stop. Let the application, let the section 5 application in connection with strike off from late. Stop. Appellant shall be appellant in FMAT MB1 of 2025 shall be at liberty to take necessary steps for early hearing of section 5 application. Stop. Next paragraph. Let the present appeal, in this appeal, paper book is filed. In your appeal, have you filed in the department? Next paragraph. Since paper book has already been filed, in the present appeal, let the appeal appear before the next available circuit. Let the appeal appear in the second week of next available circuit for hearing. In the meantime, you take steps.
I was running a pressure and they imposed a fine of 4,90,000. And on the premises that I am not paying fine, they have logged my pressure unit. And I have shown that I have made the payment. My lord has asked them to take instruction. I am seeking for an interim order to allow me to run this pressure unit.
Mining.
Page 39 and thereafter DD.
Where is that order for payment? Page 36 is the order relating to payment.
See the last order, that is page 34, whereby they have closed it. Page 34.
Page 34.
January 2025. Now, my lord, under-
Just a minute, just a minute, just a minute. January. What is the date of the order? Page 36.
36 date is, my lord, there is no date.
Yes,
June 2024.
June to, where from you are getting this?
That is page 38, my lord, at the bottom before the signature. June 2024.
25th June 2024. At the left hand side, there was an endorsement forwarded. But there is no other date. This is 25th June 2024. Just a minute. So fine amount is 4,90,000. You are paid. But subsequently you have suffered this order by which authority has directed to close down the unit.
Two things are there.
Now here, in last occasion you submitted that you have made the payment.
My letter, thereby I have paid it without prejudice to my right, and page 41 is the DD. Now, what I am on today, my lord, my paramount argument is, my lord, violating the principle of natural justice, these orders were passed. Now, my lord, that will be decided after affidavit. my lord.
Whether this you are entitled to get recovery or not, relating to penalty.
Yes, that will be decided after.
But let the unit be allowed to continue.
Now, my lord, first of all, my lord, they cannot stall it under the guilt of their own order. If my lord once come to page 37, my lord.
Yes, page 37, I want,
Paragraph, my lord. Ask two lines. If my
just a
lord-
minute, the amount of. Yes,
No, my lord, the only, my lord, first of all orders were passed behind my back. Second, my lord, as per their own order, they say that in the event the payment is not made within 7 days, the remedy available to them is to make an entry in my record of land and to recover the same under the said arrears of land revenue in terms of the. said-
now if since the payment has been made, now where is the difficulty in permitting the petitioner to run the?
Despite the various directions and penalties imposed in past, you have not desisted from illegal extraction. My lord, this writ petitioner, my lord, it's not the first.
Very well, past there was an incident. But where is the scope given to the petitioner to present his case? Yes, without hearing the petitioner. Unilaterally, this order is to be passed. Ms. Das? And petitioner has already complied with the order. So far the payment of penalty, deposit of penalty is concerned. So therefore allow him to run the unit. Since he has made the payment, let the issue be decided on exchange of affidavits. Very well, then I am setting aside both the orders. Setting aside both the orders, payment is to be kept in abeyance, and you grant an opportunity of hearing to the petitioner and pass a final order. Choice is yours. Let me set aside both the orders, since without hearing the petitioner, this order was passed. Decide the issue or revisit the issue and after that, an order is to be passed. Till then, since payment has been made, that is to be kept in abeyance. That can be done. So then file your affidavit. In the meantime, permit the petitioner to run the unit. It's a crusher unit or what is crushed there?
Stone crushing.
Stone crusher unit. You have challenged both the orders.
Yes.
Writ petition is heard in presence of the learned advocates representing the petitioner. And the respondents. By presenting this writ petition, inter alia, challenge has been thrown to the orders dated challenge has been thrown to two orders. First one is dated 8 January to first one is dated. Challenge has been thrown to two orders. First one is undated, and the second one is 8 June. Second one is dated 8 January 2025.
Every order in paragraph number 3, they have said that in this regard, an order dated 24 June. Therefrom, we gather that this will be the.
Stop. But in that order, individually, there is no date. Stop. It is submitted that allegation against the petitioner is illegal extraction, transportation and dumping of stone boulders from the land which is under possession of the petitioner, for which by the first order a penalty of rupees 490,000 was claimed against the petition. By subsequent order dated 8 January 2025, Tehsildar, Sri Vijaypuram, directed the revenue inspector of circle number 5 within bracket 5 and Patwari circle number 13 within bracket 13 to close down the operation of stone crusher unit with immediate effect. So, when this payment was made, really you express your stand in your affidavit in opposition, what further amount, if at all, if the allegation against the petitioner is substantiated, then you will disclose it that further what amount is required to be paid, or at all petitioner would be permitted to run the unit. But at present, since without hearing this order was passed, this order suffers from violation of natural justice. Yes. What was I telling? Close down. To close down. Stop. Next paragraph. It is submitted on behalf of the petitioner that on 9th January, penalty fine of rupees 490,000 was paid by submitting a demand draft stop. It is also submitted that first undated order passed by Deputy Commissioner South Andaman District or South Andaman, Deputy Commissioner South Andaman, and subsequent order dated 8 January 2025 issued by Tehsildar Sri Vijaypuram were passed without granting opportunity of hearing to the petition. And the challenge which has been thrown to these two orders is based on certain grounds, one of which is violation of natural justice. Next paragraph. Learned advocate representing the respondents today has not produced any material to substantiate or has not produced any material to dispute the submission made on behalf of the petitioner relating to violation of natural justice. Stop. Nothing has been shown which goes to show that petitioner was granted opportunity to present his case before passing these two impugned orders. Stop. However, it is submitted that after order was passed in the month of June 2024, whereby fine was clamped upon the petitioner, payment was made by demand draft dated 9 January 2025. Just on the next date, subsequent to the order passed on 8 January 2025. Next paragraph. This court on prima facie, this court having considered the submissions made on behalf of the parties and on perusal of the impugned orders, prima facie finds that a case has been made out on the count of violation of natural justice, since opportunity of hearing was not afforded to the petitioner, and unilaterally decision was taken by the respondent authorities as emanates from the order dated or order passed by Deputy Commissioner South Andaman and subsequent order dated 8 January 2025 passed by Tehsildar Sri Vijaypuram. It is true that fine was paid at the belated stage just after the order was passed on 8 January 2025, directing the revenue inspector, concerned revenue inspector and Patwari to close down the unit. Stop. Next paragraph. Since payment was made On 9 January 2025, respondents respondents are directed to permit the petitioner to run the stone crusher unit till disposal of the writ petition. Stop. Affidavit in opposition to be filed by 3 weeks from date. Affidavit in reply thereto, if any, be filed by 1 week thereafter. In the affidavit in opposition, respondent shall be at liberty to demonstrate, or the respondent shall be at liberty to disclose further amount which is required to be paid by the petitioner due to delay occurred in making payment in terms of due to delay occurred in making payment of fine in terms of the order dated in terms of the order passed by Deputy Commissioner South Andaman. Stop. List the matter before the next available circuit after the time fixed herein above for filing affidavits.
This is my right. Because my letter is also over.
Record this, since the petitioner, record one line, it needs to be recorded that petitioner made such payment without prejudice to the rights and contentions, without prejudice to his rights and contentions in the pending writ petition. Next circuit come by.
They refuse on the part of the petition civil suit, they cannot refuse.
Next circuit. So do you want to file a supplementary affidavit? Yes, give the file to me. Learned advocate representing the petitioner prays for leave to file supplementary affidavit in order to bring on record certain other relevant documents. Stop. Let such supplementary affidavit be filed by 1 week with an advance copy upon the learned advocate representing the respondents. List the matter before the next available circuit in the 2nd week, or list the matter in the 2nd week of next available circuit. Yes, Ms. Das's evidence may be, yes.
Number 4, WPS 7.72 of 25.
This matter, my lord, next senior advocate is appearing for petitioner.
Who is your senior advocate? Who is senior advocate? Okay. He is appearing for whom? Where is he? Where is he? He is in which court? Chief Judicial Magistrate, and High Court is sitting. You will not get time. This is the highest court in this part of the country. So if the senior advocate is appearing in some other court, he will not get the benefit of adjournment. As paid for on behalf of the petitioner, hearing of the writ petition stands adjourned. List the matter before the next available circuit.
WPS 77 after 25.
Newly filed matter? Yes, 7th February. At the time of call, learned advocate, you are for the petitioner. At the time of call, learned advocate, where is Mr. Jaipal? Why Mr. Jaipal is sitting at the back? At the time of call, learned advocate representing the petitioner has prayed for accommodation to effect service of notice upon the respondents. Learned advocate for the petition, next paragraph, learned advocate for the petitioner is directed to serve notice upon the learned advocate's, learned advocate representing the petitioner is directed to serve notice upon the respondents by 10 days from date and file affidavit of service on the next day. List the matter in the second week of next available circuit. Yes.
WPS 70 of 525.
Who is for the respondent? Have you served?
Lordship, I am appealing for the respond, Lordship. No copy has been served, Lordship. Let it go to the next circuit, man. 6, 7, 8.
Let me dispose it of directing the learned advocate representing the petitioner to serve copy of the petition upon him.
Lordship, let them serve the department, Lordship.
Well,
Kindly, Lordship, I am praying, Lordship. It is not that I don't want to give them any opportunity. Let it go to the next circuit when after 7 days, next circuit is there, Lordship.
But since you are appearing, if this is a different matter, Mr. Mishro, definitely this court would have passed, would have accepted your.
Lordship, I will use my opposition or in 7, 6, 7, and 8.
In this matter, I will not permit you to use opposition. Since you
Lordship,
Since-
Lordship, it is not that I have opportunity to use my opposition, Lordship, when I am appearing on behalf of the respondent authority without copy also, because I have seen the list and I am appearing, Lordship.
appropriate matter, you have the right to use an opposition and court passes such order. Since these are the usual orders, you are aware and in some
No,
of the
Lordship, there is something difficulty because
Right.
let them serve, let me go through it, and thereafter, if it is a similar matter, I will not object also.
allow this court to pass to express its mind that why court is not will not permit you to use opposition since this is an usual.
Lordship, my prayer may be recorded, and thereafter any order may be passed, Lordship.
This is adamant, Mr. Vishnu.
My prayer may be recorded that I have prayed for filing the affidavit in opposition. This court has denied me. I know where I have to go.
This is not an appropriate stand because this is not a different matter.
Lordship, without the copy, without having the copy, Lordship, how I will submit before this honorable court? So I am praying. Otherwise, why should I will pray, Lordship? If they have served, let them file affidavit of service. I will not tell anything.
Whether service is complete. Tell me that
Let them file affidavit of service, Lordship.
Also, I will bring the copy.
why you are not with the copy? The other side is taking for that praying for time. As prayed for by the learned advocate. Now, the learned advocate representing the petitioner, has prayed for time to complete service of notice upon the respondents. Stop. So please don't appear, Mr. Mishro. Since your appearance will not be recorded today.
Lordship,
No.
I don't want to record my submission, Lordship. I am not about the fees.
Yes, sir. Very good. কি বললো? Stop. Let the service, let the notice be served upon the respondents by 7 days from date, and an affidavit of service be filed on the next date. List the matter before under the same heading before the next available circuit. Don't record appearance of the respondents. Yes.
Item 7, WPS 7, 25.
Similar matter.
Service.
Yes.
Mr. Mishra, you have received copy.
No, Lordship. No, Lordship.
Service is complete. Show me service. Yes, it has been served on 7th February.
7th. Today is 10th. Because I am not well, Lordship. I have not come to court. Let same order be passed. Let same order be passed.
Yes. Where is your application? Shall I record your appearance?
As your Lordship wish.
Very well. Then I will record you. Where is your application for new connection? Page 19, 17 June 2024. Yes. 17 June 2024 application. Then just a minute. Assistant engineer respondent number to do one thing. This order, respondents are represented. Matter is heard in presence of the learned advocates represent. Yes, your appearance is recorded.
Obliged, Lordship. Obliged. Deeply obliged.
Disposed of. At another night, the notice dated 5th February 2025 is taken on record. Same order, same order.
Obliged, Lord.
WPS 75, 25.
Yes. Service. Mr. Mishra, service is complete.
Lordship, here some difficulty is there. I have got the instruction. I have to file affidavit, Lordship.
Why?
Because they have not challenged the rejection order, Lordship. His application has already been rejected.
Page 12.
So let me file affidavit in opposition. He has not enclosed that. Let me file opposition, Lordship, in this matter. Please.
Presenting the licensee says is submitting that there is a rejection order.
This is essential. I have filed
No,
application.
no,
Application.
no. Once it is rejected, then you have to challenge that rejection order.
Apply within 30 days. He has not.
Very well, then I have to pass an order directing Mr. Mishra to place before this court on the next day, before the next circuit, the rejection order passed by the authority.
I will file opposition, Lordship.
No, not opposition, you produce the rejection order.
Lordship.
Learned advocate, the matter is heard in presence of the learned advocates representing the petitioner and respondent authorities. Stop. Mr. Mishra, learned advocate representing the respondents. Now, Mr. Learned Advocate, Mr. Mishra, Mr. Mishra, who appears on virtual mode today, submits on instruction that on previous occasion, application of the petitioner was rejected by the concerned respondent authority. It is further submitted that that rejection order, which has been suffered by the petitioner, is not under challenge in the present writ petition. Stop. Next paragraph, on perusal of the writ petition, it is on perusal of the writ petition, it is found that rejection order is not enclosed to the writ petition. Stop. Next paragraph, learned advocate for the respondents is directed to obtain instruction and produce rejection order on the next date. List the matter before the next available circuit under the same heading for further consideration.
Obliged, Lord.
WPA 102 apartment 3.
Next circuit. No order, next circuit. Respondent. Mrs. Next circuit.
WPA 331 apartment 4.
I pay for this one.
Yes.
I pay for this one. I learned for the values here.
Next circuit. Next up,
Again, WPS 437 of 2024.
item number 14, 13, 13. Next circuit,
14, WPS 5 of 2024.
next circuit. Mr. Chakraborty is appearing.
Is into matter, but.
Next circuit, affidavit. Let me see. Affidavit in reply. You are for the respondent. Say so. So affidavit, who is appearing for the respondent? SC Mishra. The electricity matter. Where is Mr. Mishra? Online? At the time of call, learned advocate representing the petitioner has prayed for extension of time to file affidavit in reply. Stop. Time to file affidavit in reply stands extended by 2 weeks. By 2 weeks. Stop. List the matter before the next available circuit, or list the matter in the second week of next available circuit under the same heading.
WPS 546 of 2024.
Yes. The yes, opposition is there on record.
Reply. And we will file the list. They got it.
Let the matter be placed before the next available.
2 weeks time.
Affidavit in opposition has been filed on behalf of the respondents and same is on record. Stop. Today, copy of the affidavit in opposition has been made over to the learned advocate representing the petitioner. Petitioner prays for accommodation to file affidavit in reply. Stop. Let affidavit in reply be filed by 2 weeks from date. List the matter before the list the matter in the second week of next available circuit under the same heading. Next.
17, WPS 40 of 2024.
Who is for the respondent? Where is Mr. Sibabalan? Where is the interim order passed? By which order? Show me. By which order interim order was passed? Yes, yes. 13th November 2024. Just a minute. Till 15th February it is. not to demolish. Structure may be sealed, but not to demolish the structure. Pleadings are complete. Yes, it is recorded in my order, which was passed on 28 January 2025. You are for the petitioner, who is for the respondent, Mr. Shiva Balan. At the time of call, respondents are not represented. Stop. However, petitioner is represented by learned advocate. Stop. List the matter before list the matter before the next available circuit under the same heading. Interim order passed earlier stands extended till till 31st March 2025 or until further order, whichever is earlier.
Petitioner, my lord. Last week, the pleadings are completed. Now the matter is ready for it. And there is a interim order, my lord, passed on 16th of December 2024, whereby allowed the authorities to pursue the proceeding, but not to pass final order that was extended till today. Initial order is on 16th December 2024, paragraph number 18, paragraph number 8.
When the initial interim order was passed,
16th of December. Paragraph number.
the first order was passed on 16 December till the last date of the first circuit of 2025. Then it was extended. By which order?
But last order.
Just 15 January probably. Just. Yes, that is what I am asking. Now, whether the order has been passed in the meantime, because come to the order dated 16 December 2024. Why?
Order is not, how can it pass without the legal?
No, no coercive order, no coercive steps. Order can be passed, but a coercive step cannot be taken. Any coercive steps, order can be passed. But if in terms of the order, any adverse steps are required to be taken against the petitioner, that cannot be taken. So where is the order?
It's not passed, my lord.
Hearing concluded last week, probably today or whatever will be passed.
Then the order has to be seen by this court. That what order the airport authority, what is the matter about?
Said, my lord, these petitioners are in possession of a land from the year 1929 onwards. There are documents to substantiate that they are in possession.
Adverse.
Adverse. Now the Airport Authority of India claims that land to be their land. They preferred 3 estate appeals before the estate officer, Andaman Nicobar administration on 2 occasions, by the airport's estate officer on 1 occasion, and all those occasions they failed before the court of law. all those proceedings were culminated in my favor. Now, once again,
On the
yes,
point of jurisdiction.
whatever may be, it was
On the
dismissed.
point of jurisdiction.
It was dismissed. Now what happened, my lord? They have initiated a fresh proceeding. Fresh proceeding under the Airport Authority Act. My
The
lord,
previous attempts made by the airport authority was considered by which authority? By the civil court or by
Once to ADM.
on two occasions by.
under 1966 regulations?
No, under this public premises.
Oh.
Public premises act. Now, on all the occasions they failed. Up to 2024, they have failed. Now they initiated a proceeding under the Airport Authority Act. Now that proceeding, first of all, that proceeding, we say that without jurisdiction.
Not maintainable.
Not maintainable. Second is that, my lord, for the purpose of initiating a proceeding, you must be the owner of the land. Actually, all along this proceeding that we were not aware, they are not the owners of the land.
Now, on culmination of these proceedings, final order is to be
Is
passed.
to be passed. And it is without jurisdiction, this is our case. And they are not the recorded tenant of the land.
No, I'm disputing.
No, the
So also they
documents
were-
are there.
No, the documents is with me.
No, but I will direct, since you have already filed your affidavit in opposition, you file an supplementary affidavit in opposition disclosing the order which is to be passed by, or which is disclosing the order if passed by the Airport Authority of India.
Hello.
Because it has to be on record before taking decision. Court has to consider that what is the outcome of the proceedings which has been initiated under the Airport Authority of India. Let's take them. Though affidavits have been complete, but no order has been passed by the concerned authority of Airport Authority of India in terms of the order dated 16th December 2024. Stop. Learned advocate representing Airport, you are representing Airport Authority of India submits that soon an order is to be passed on conclusion of proceedings. Stop. Next paragraph. If order is passed upon bringing the proceeding into logical conclusion by the concerned authority of Airport Authority of India, leave is granted to the leave is granted to the concerned authority of Airport Authority of India to file a supplementary affidavit in opposition disclosing such order. Stop. Next paragraph. Interim order which was passed by a coordinate bench on 16 December 2024 restraining the Airport Authority of India from taking coercive steps against the petitioner, which was subsequently extended video order dated 15 January 2025, stands extended till 31st March 2025 or until further order, whichever is earlier. Next paragraph, list the matter under the list the matter in the second week of the next available circuit under the same heading. In the meantime, you disclose.